Hello, I'm Bill Godshall, founder and executive director of Smokefree Pennsylvania, a nonprofit organization that since 1990 has been advocating local, state, and federal policies to ban smoking in workplaces, reduce tobacco marketing to youth, hold cigarette companies accountable in civil litigation, increase cigarette tax rates, fund tobacco education and smoking cessation services, inform smokers that smoke-free tobacco and nicotine products are far less hazardous alternatives to cigarettes, and to ensure that smoke-free alternatives remain legal and affordable to smokers. In 2007, I convinced Senator Mike Enzi to amend the Tobacco Control Act in the Senate to require color graphic warnings on all cigarette packs, and 2 decades ago, we urged the FDA to approve NRT for over-the-counter sales. For disclosure, neither I nor Smokefree Pennsylvania has ever received any funding from any tobacco, drug, or electronic cigarette company or trade association. I'm here to once again urge the FDA to stop protecting cigarettes from market competition by far less hazardous smoke-free alternatives, to correct or clarify FDA's many inaccurate and misleading claims about low-risk smoke-free tobacco and nicotine alternatives, and to keep all smoke-free alternatives legal and affordable for smokers. More than 99% of all tobacco-attributable mortality and healthcare costs in the United States are caused by repeated inhalation of tobacco smoke, while less than 1% of mortality and healthcare costs are caused by the use of non-combustible tobacco and nicotine products. Epidemiologic evidence indicates that cigarettes are at least 100 times more hazardous than smoke-free nicotine and tobacco products marketed in the U.S., including smokeless tobacco, electronic cigarettes, and NRT products. While quitting all tobacco and nicotine is an effective way for smokers to improve their health, switching to smoke-free alternatives reduces smokers' risks nearly as much as quitting all tobacco and all nicotine use. Survey and sales data indicate that more than 1 million smokers have quit smoking by switching to smokeless tobacco products, that several million smokers have switched to smoke-free electronic cigarettes in just the past several years, and that many smokers use NRT products as temporary or long-term alternatives to cigarettes. Since there have been many reports of suicide, suicidal thoughts, and adverse cardiovascular events associated with Chantix, I urge the FDA to consider removing Chantix from the market, or to at least require additional warnings to better inform consumers of its risks. I also urge the FDA to not fast-track the approval process for any new drug or treating tobacco dependence. After seeing what the FDA's not done on Chantix, I would not want to see another drug like that approved. Although FDA has approved many NRT products to treat tobacco dependence, NRT products have a 95% plus failure rate for treating tobacco dependence and for smoking cessation. Therefore, I urge the FDA to disapprove all NRT products as treatments for tobacco dependence, and to not approve NRT products as smoking cessation aids unless clinical trials find a 20% or higher success rate, or to at least require manufacturers to notify consumers of the 6-month and 12-month success rates the product was found to have for both smoking cessation and for achieving nicotine abstinence. But since NRT products are far less hazardous alternatives to cigarettes, and since most NRT products are consumed for off-label use as either temporary or long-term substitutes for cigarettes, the FDA should approve all NRT products as temporary and long-term harm reduction alternatives to cigarettes. The FDA should adopt R.J. Reynolds' citizens' petition to replace the intentionally deceptive, not a safe alternative warning on all smokeless tobacco products with one that informs consumers that cigarettes are far more hazardous. And the FDA should propose a similar warning for cigarette packs, since smokers are at greatest risk. Warning labels on NRT products should also state that the product is far less hazardous alternative to cigarettes, and should encourage instead of discourage smokers to continue using NRT as long as they continue to smoke. If FDA implements these regulatory changes, manufacturers of electronic cigarettes, dissolvables, and even smokeless tobacco products may consider applying to the FDA to market these products as nicotine replacement therapy tobacco harm reduction alternatives. NRT manufacturers should consider more aggressively marketing their products to smokers as well. In contrast to most NRT products that have been marketed in the last 20 years in $40 plus packages at pharmacies only, R.J. Reynolds Niconovum is test marketing Zonic nicotine gum in $3 10 packs, that's 30 cents per piece of gum, at convenience stores throughout Des Moines, Iowa. These kind of marketing changes are necessary, and I'm glad the FDA has approved that for that marketing. Regardless of regulatory changes for NRT products, the FDA should never again ban or impose unwarranted or unreasonable regulations on electronic cigarettes, dissolvables, or smokeless tobacco products because these products have nearly identical health, safety, risk-benefit profiles as do NRT products. In 2009, in an attempt to justify its unwarranted and unlawful import ban on electronic cigarettes, then FDA Deputy Commissioner Josh Sharfstein misrepresented the agency's laboratory test findings on e-cigarettes to scare the public and to falsely claim that the products were target marketed to children. But even after FDA concurred with Judge Leon's ruling prohibiting FDA from banning e-cigarettes as unapproved drugs, the FDA has still refused to correct or clarify any of its inaccurate and misleading claims about e-cigarettes. Even worse, the agency has issued additional misleading claims since then about e-cigarettes. And yet, e-cigarette sales continue to skyrocket and should surpass NRT sales next year, whose sales have remained stagnant about $1 billion annually for the past decade. The FDA has repeatedly stated its intent to propose a deeming regulation to apply Chapter 9 of the Tobacco Control Act to e-cigarettes, but Sections 905 and 910 would ban all e-cigarettes, and other provisions of Chapter 9 would also decimate the e-cigarette industry, protect cigarette markets, and otherwise threaten public health. The FDA should not propose or approve any regulation that would deny cigarette smokers legal or affordable access to less hazardous alternatives. The FDA has also denied the growing body of scientific evidence and consensus among experts by falsely stating on a web page entitled Health Fraud. It says, to date, no tobacco products have been scientifically proven to reduce risk of tobacco-related disease, improve safety, or cause less harm than other tobacco products. Is there anybody in this room that truly believes that smokeless tobacco and e-cigarettes are just as hazardous as cigarettes? I don't think so. The FDA should immediately take that web page off. Many other FDA and DHHS websites also contain false and misleading fear-mongering claims that exaggerate the risk and deny the benefits of smokeless tobacco products for smokers. 1 week after FDA's TPSAC issued a report that acknowledged dissolvable tobacco products are less hazardous than cigarettes and can reduce risk of smoking, the FDA issued a draft guidance for MRTP applications that denied the scientific evidence and would require smokeless tobacco companies to spend tens of millions of dollars on unnecessary studies just so the FDA might consider allowing the company to truthfully inform smokers that smokeless tobacco is less hazardous than cigarettes. Smokers have a human right to truthful health information and legal access to less hazardous alternatives, and the FDA has an ethical duty to inform smokers that all smoke-free tobacco and nicotine products are far less hazardous alternatives to cigarettes, and to keep all less hazardous alternatives legal and affordable for smokers. Instead of wasting public dollars defrauding the public, abusing its authority and the rights of tobacco consumers by demonizing and campaigning against all tobacco use, the FDA, CDC, Surgeon General's Office, and other DHHS agencies should focus on reducing the leading cause of disease, disability, and death, which is cigarette consumption and daily smoking, not tobacco or nicotine use. Abstinence-only prohibition policies and propaganda didn't work for alcohol, marijuana, or sex, and they don't work for tobacco either. I think it's important to point out that the 4 previous speakers before me all oppose all tobacco use and all urge the FDA to ban e-cigarettes, and yet they're here today, and I applaud them for saying we should judge these NRTs based on compared to continued smoking, but when it comes to judging e-cigarettes and smokeless tobacco, they want to judge it against quitting everything, and that's the problem. You can't have different rules apply. What's the difference between a dissolvable tobacco lozenge and a dissolvable nicotine lozenge? Nothing. You can market it right now as either or. Under the law, if I have a company and I want to sell this product, I say, well, should we sell it as a tobacco product or should we sell it as an NRT? And the problem is there's 2 routes right now. And the one, it's good nicotine, it's life-saving medicine, and the other is addictive, deadly, evil tobacco product, and it's the same product. It's just a matter of how you're marketing it. So we need to really look at the bigger, broader issues of public health instead of just the minutia of each subsection of this law. And I'd be happy to answer any questions on any of these issues. Yes?
Just to tease out one section of this, I think there's substantial evidence, or at least we've heard from a lot of groups and heard a lot of people speak about the serious health consequences of chewing tobacco. Do you include that in your calling all non-combustible cigarettes as relatively
Yeah,
safe?
the epidemiologic studies on chewing tobacco found that it's about 99% less hazardous than cigarettes. And because of the 1986 Comprehensive Smokeless Tobacco Education Act mandated the warning on all smokeless tobacco products that says this is not a safe alternative to cigarettes. No, it's not a safe alternative. It's just 99% less hazardous. And that's a deceitful warning. It's intentionally deceptive to, and I know because I was around when that discussion occurred 25 years ago, and the people behind that were smokeless tobacco prohibitionists. They didn't want smokers to switch to smokeless tobacco. And I say, well, why? And they say, we want them to quit. And besides, if they switch to smokeless, that won't achieve our goal of destroying the tobacco industry. And that's really the problem you have here. A lot of people that claim to be public health advocates are tobacco prohibitionists, and their goal is to wipe out the industry, and they don't want smokers to switch to any product that the industry profits from. And right now, R.J. Reynolds, their statements recently, they're having higher profit margins from their sales of Grizzly smokeless tobacco than they are from their Camel cigarettes, and that's good, because as long as tobacco companies can make more profits selling a smoke-free alternative than they can selling a cigarette, they have a vested financial interest. And the FDA should encourage these kind of products to be marketed.
So with these images I have in my head of these young men who've had lost their pieces of their jaw and such from chewing tobacco, can you include the references to those epidemiologic studies in your submission to the docket?
I'd be happy to, and I've already sent them to the FDA at least 7 or 8 different times in previous dockets, and all that information's been ignored, including in the MRTP panel. They just totally ignored it. In fact, the FDA told the MRT panel to ignore these harm reduction issues, the risk of smokeless. And the IOM, when they contracted with the Institute of Medicine, they instructed them not to talk about the comparable risk of different tobacco products, because this is unfortunate. The FDA has this prohibitionist mentality. Why do we tell tobacco companies they're not allowed to tell smokers that smokeless is less hazardous? That's to keep people smoking. And even the tobacco companies say, we'd be happy to tell them the truth about these less hazardous products, and the FDA is saying, no, you can't. You got to keep selling them cigarettes instead. So, and back to your question about chewing tobacco risk, most mouth cancer, oral cancer deaths, 75% of all oral cancer deaths in America, according to the CDC and according to the American Cancer Society, among men, are caused by cigarette smoking. The risk of mouth cancer from smokeless tobacco is about 1/10 of the risk of smoking causing mouth cancer, and most mouth cancers that do occur in smokeless users occur in people over the age of 65. Those few cases, and yes, there's everybody that's ever used a smokeless tobacco product and got mouth cancer under the age of 30 is now being hired by some anti-tobacco group to run around the country and show their jaws. That's not science, that's fear-mongering propaganda.
I had one quick question for you. Could you explain a little bit about your statement that sections 905 and 910 of the Tobacco Control Act, or the Food, Drug, and Cosmetic Act as amended by the Tobacco Control Act, would ban e-cigarettes?
Yeah, Section 910, when it was enacted in 2009, any product, currently it's cigarettes and smokeless tobacco that are regulated by Chapter 9. And it said that any product that wasn't on the market before February 15th, 2007 would either have to apply for a substantial equivalence application that it was substantially equivalent to a product already on the market before 2007, or they'd have to submit a new tobacco product application. And then Section 905 said anybody that's marketing one of these products in 2010, 2011, could still market the product, but they had to get their substantial equivalent applications in. I think it was May 2011 was the deadline. Well, if you deem, so it's too late. The deadline's already passed for any products that weren't on the market by 2007 to get them grandfathered in. And so now if you take a new product like electronic cigarettes, or some of these dissolvables, and say, okay, now we're going to apply you to all Chapter 9 regulations, Well, they missed the deadline. And at the time, FDA, back in 2009, was telling the federal courts, e-cigarettes are not tobacco products, they're drug devices. But now, if you pass the deeming regulation, you'd be saying, okay, all you e-cigarette companies should have known we were going to deem you as a tobacco product in 2013, and you should have known that back in 2009 to get your substantial equivalence applications in on time. So you'd have to amend those sections, and there's many more. I mean, the section 911, the modified risk tobacco product section, would make it a crime for any e-cigarette company to market their product as not emitting any smoke. Just making a claim that it's smoke-free is a federal felony under Chapter 9. So you really need to look through, and I've presented this many times to many people at the FDA, all these problems with Chapter 9 and how they actually threaten public health instead of benefit public health. And to just say, let's take all this new category and apply them to the rules that we applied to cigarettes and smokeless 3 years ago, it just doesn't work. And I don't think that regulations for these new products should be appropriate for protecting public health. And if you go through Chapter 9, you'll see many of these regulations were not, they have no benefit for public health. They were just in there, I think, to demonize this, releasing the list of potentially hazardous and hazardous chemicals. What's that going to do how's that going to benefit public health? But that's off subject, but I could go on for an hour of all the problems of Chapter 9 and how it doesn't benefit public health, but you guys are now required to uphold the law, so you're required to threaten public health, which is not, so you got a quandary you got to deal with.
Thank you. Thank you very much.
Thank you.
Appreciate it.